All right. Well, it is 5:02, so we get started. First of all, good afternoon and welcome everyone to the estate planning webinar presented by Financial Partners Credit Union in partnership with AmeriEstate. My name is Mario Osorio, and I'm the SVP of Investments and Insurance Services for the credit union. We hope that you find the information shared with you today helpful as you look at to make future estate planning decisions. At this time, I would like to turn the presentation over to Michelle Reese Johnson, who will be conducting the webinar. Michelle, please take it away.
Thanks, Mario. Hey, everybody. Happy month end, 5 o'clock. The bell has rung. I hope everyone hit their numbers today or whatever you're up to. I'm Michelle Reese Johnson, Vice President of AmeriEstate Legal Plan. We've been doing estate planning for 27 years now and partnering with financial partners for about 15 of those years. So Financial Partners has been a very integral part of AmeriEstate with their client base, their members, making sure that they are educated and have proper estate planning. So the best thing about doing this webinar is educating a lot of people at one time because it is such an interesting subject. I personally think it's interesting, and so many people just don't understand estate planning and what it really means for them personally in their lives. So that's why I like to bring it home and kind of give you guys some real life stories and help you understand the need for estate planning. So let's move on to the next slide. So first thing is there's a little chat button in there. I'd like to know, in this group, we have about 68 people with us. That's great. We had about 300 sign up. That's great. But out of the people here in this room, do any of you have any powers of attorney for health or finance, or just a will, or do any of you have an estate plan or a living trust? Anybody, you can raise your hand, I think, and put something in the chat there. Kind of be interesting to see who might be already set up. A lot of people do have estate planning documents, and sometimes they're pretty old. So we're going to talk about that as well. So let's see. Phyllis has something. Tom doesn't have anything. Do when? Nope. Living trust, will, yes. Yes, good. You have it all, Kathleen. Good job. Glad you're here. Yes. Afraid not. I know. Not yet. Yeah. Yes. Well, we got some yeses. We have quite a few yeses. So thanks for being here. I think it's always good to refresh yourself on estate planning and why the heck do you have this document in your possession, right? So I'm going to help go through that with you. Oh, living trust and a healthcare directive. Good job. I'm so impressed with people that have this. I really am, because most of the time, you know, of course, people are calling us because they don't have anything in place. So, okay, some people have had it when they were married, but not married anymore. Self-written will, okay. Very outdated. Yeah, we'll talk about that, Karen. So very cool. Thank you, everybody, for joining me on that. I love to hear how people are familiar or where they're at in their lives with their important documents. First thing is, let's talk about who needs a living trust. Not everybody needs one. But people that have these types of assets or situations listed here need a living trust. You're a homeowner. That's it. You got to have one. Business owner, you should have one. Parents of minor children, absolutely. Special needs, oh my gosh, yes. We'll talk about why. Single people, if you're single and let's say you don't have kids, you still might have assets. So single people need an estate plan if they qualify, if they have certain types of assets like homes, investment accounts. Maybe, they do have kids, minor kids. You need a trust. You possess assets that trigger probate. We'll talk about that. What are those assets that trigger probate? Investment property. A lot of people don't think about the other stuff that they have. It could be land. It could be investment property. It could be royalties. It could be airplanes, motorhomes, expensive toys, things like that. And also incapacity planning. Anybody who becomes ill, maybe has Alzheimer's, they need to set up these documents before those things happen, and I'm going to tell you why. So the first thing we like to talk about is the ways to set up an estate plan. The first thing is the do nothing plan. The second thing is a will. The third thing is just adding people the title to your stuff in case you pass away, they get it. So that's just like the Band-Aid effect. And then the best and last choice is the living trust. That is the best choice for most of us here on earth, working, accumulating things, having families. So, but these are the most common ways. And of course, the first way, the new do nothing way, is the do nothing way. I think most people think about it, but they don't do anything about it. And that's pretty typical. I would say 70% of people do not have anything in place, not even a will or a power of attorney. You're just hanging out, right? And doing your thing. The next thing is just a simple will. A lot of people think, okay, I signed up for this free thing and they gave me a free will. Great. Okay, well, a will is okay. At least it tells the courts when you die who's going to get your stuff and maybe who your guardians will be for your minor children. That's what a will do for you. But if you have certain types of assets and you have minor children or special needs children, a will is not going to cut it at all. And the other way is adding people the title. We see this all the time because people do not understand that that's a problem. They just think, well, we have this property and we have 5 kids and my oldest, let's just put him on title because if something happens, my dad, your dad and I, at least it won't go through probate because he's already on title, right? A lot of people think that. I'm going to talk to you about why that's not a good idea in a little bit, in a few other slides. And the best way, like I talked about, is all these things are going to protect you. A living trust, I don't know if you've guys, I'm sure most of you have heard about that ugly word probate. That's just a really bad word. We don't like that word. But assets will go through this probate process based on the state that you live in and based on where your assets are located. So you could live in California, but you can also have property in other states. So if you pass away without any kind of a plan in place, even if you just have a will, those assets are going to go through probate. For instance, real estate will go through probate, even if you have a will. And if you have property, and a lot of people are buying stuff all over the place now, Texas, Virginia, Tennessee, these are really hot places, right? They'll have to do a probate. Your executors will have to do a probate in those states. So they'll have to hire an attorney in that state and give it through that process. If you become incapacitated, like I said, your affairs are going to be kind of frozen because nobody can act on your behalf anymore. What does that mean? Well, the courts have to step in because you're still here, but you didn't set up that power of attorney. So that's called a living probate. We'll talk about it a little bit more. And we want to just make sure that everything is locked up and all these things that you've accomplished in your life here on earth, all these things you've bought, the children you have had, the investments that you have put with financial partners, or maybe some life insurance and things like that. We want to make sure that everything's protected. And we want to protect those things. The number one reason people do an estate plan is they want to stay out of probate. Well, let's talk about that probate situation, because it's kind of fuzzy, isn't it? Because most of us have never been through it. I personally have never been through it myself, but I know so many people that have. They tell me the stories, and so I told Caroline, I go, it's like a 3-ring circus. It really is, and the reason why I call it the 3-ring circuit is because, I'm going to go back to this slide because it's kind of fun to look at while I'm talking. Cirque du Soleil, right? So when the circus comes to town, they're going to advertise, right? Okay, so let's look at that advertisement. When you pass away without an estate plan, meaning if you just have a will, or you have nothing at all, which is what most people have, they have nothing. It has to go, your estate has to go through probate. And how that starts the process is the courts have to appoint an executor, and they have to put an ad in the paper about, you might have seen the back of the newspaper, in olden days when we used to get our newspapers, but online, you'll see who's passed away, right? And then you'll see probate notifications, and you'll see Mr. William Smith passed away. Here's the estate number of his case. Anybody interested in, any debt collectors, anybody interested in knowing about this case, show up to court on this date. So there's your ticket right there. And so we're going to grab that ticket, and we're just going to show up to probate court and sit there and listen to what the neighbor had. I'm going to see what Mr. Smith had in this estate. So they're going to show up, and people that find out are going to come in and listen to that probate as well. So it's public. Living trusts are private, but if you pass away without a trust, or you just have a will, it needs to be advertised in the paper, and everybody, creditors, need to know what's going on. So that's your ticket. And then once they get there, they can contest, hey, listen, I was the, his best friend, and he promised me the blah, 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 or I was the gardener, or, some kook coming off the street can just say, yeah, him and I used to meet for lunch all the time, and he promised me he'd give me the car and the house, or it could be even a caretaker. We have a lot of that going on. So you want to be sure to make your affairs private, number one, and that's what a living trust will do. Also, probate will take a long time. The courts, especially in California, most of you are here in California, the courts are so backed up right now, and the baby boomers are getting older, and the baby boomers' parents are passing, and everybody's jammed in the court, and you can't even get a date for a minimum of 6 months to even get the process started. So you have to hire an attorney to open up the probate, and the assets are frozen. And I know Mario in the bank sees this all the time, because the kids come into the bank with mom's death certificate, and mom has nothing in place. It's just in her name. And the bank will go, I'm sorry, but we can't give you the money because we need some kind of estate plan, or we need a trust to get to access to those assets if it's over a certain value. I'll talk about some values with you. And also what happens is it's very expensive. If you've got an estate that is $1 million, and I'm talking $1 million is the gross value of your estate. It's not your house, and then plus your mortgage on it. So let's say you have a house, you have a mortgage for $500,000. You would think they would just probate on 500 equity, right? No, they want the whole $1 million. It's a statutory fee they take right off the top. So it's the value of your house, it's the value of your checking accounts, your savings accounts, your cars, your boats, your motorhomes, your planes, anything that is not in a trust or have a beneficiary on it will be stuck in this kind of probate jail, is what I call it. And so when people pass away without a will or a trust, the courts have to decide who gets your stuff and who's going to handle it, and oftentimes who's going to be the guardian of your minor children, because you didn't take the time to put your wishes in place. So that's why probate has to happen, because you haven't done anything to let the courts talk to the courts because you're not here anymore. Okay. Okay. So another good reason is when you have minor children, this is what I see a lot. People put their minor children on as beneficiaries to their bank accounts, their life insurance. Sometimes they even put their kids on title to their property, and these kids are minors. Anybody can put a kid on title to the property. They're just signing over that I'm adding junior on. That's fine. It's not fine, because if that parent dies, that kid's on title to a property and he's a minor, and it's a big problem because minors cannot sign, act on their behalf. So what has to happen? The courts have to step in, assign a conservatorship to that estate for that minor, and that minor also might not go to the guardians that you wish to go to because you haven't put a guardianship in place for them of who you want to take care of them. There's a little bit of a probate calculator just to give you a value of how much probate is going to cost based on just a $400,000 estate. I don't know anything that's valued at $400,000 just around Orange County anymore, right? You can't even buy a condo for that anymore. So just a $400,000 estate, you're looking at about 8%. Right off the top of that. So there's $32,000 that are just going to go to courts, attorneys, anybody who's serving and back and forth. So that's $32,000. That could put a kid through college. So you just want to make sure that you're not just having to pay fees for nothing. Actually, this is kind of a more detailed probate calculator. I don't know if y'all can see that. It's a little hard for me to see it, but it kind of adds up everything. Like there is real estate, 700, savings of 250, investments, 200, vehicles, household furnishings. That's all included. Everything's kind of included in the estate plan, total value. Probate cost, almost $100,000. And guess what? You don't even get anything until this probate is cleared. You're talking about 2 years that everything's stuck in probate jail. And so what that means, if you've passed away and, your kids' life continues on for your kids and your beneficiaries, but nobody can get access to the money. So it's very stressful for families because they have to start paying out of their pocket, putting things on credit cards, making sure the gardener can show up to the house, keep those utilities paid. All of that has to go on because, the house on the street that the grass isn't cut and the utilities aren't paid, you know what that's going to look like eventually. It's not going to be a pretty sight. So things have to be maintained even if you're gone. And you need to make that transition easy for the people you choose to take care of business on your behalf if you can no longer do it. So let's compare a little bit. Probate can be expensive, time-consuming, traumatic, and public. It's all of that. I would say the number one thing is traumatic. It is court, attorneys, fees, nightmares, things getting delayed, dates pushed back over and over and over again. So you continue to pay the attorneys, pay the lawyers out of your own pocket, and then maybe in a couple of years, they will release the money to you after all their expenses are paid, all the courts and attorneys are paid first. Okay? Living trusts avoid all this stuff. There's no probate fees, none. You can settle an estate very quickly when you have a living trust, by the way. California has some rules that say when somebody passes away, you have to have these, what they're called a probate notification letter. It's if you have a trust, we send these out. And that is about a 120-day waiting period. So if anybody comes back and says, well, I don't agree with what Dad said, even though it's in the trust, people still can do that. But you kind of have to wait maybe 120 days, and you can go ahead and distribute the assets. You can go ahead and sell property and just hold the money into a trust bank account until everything, the bills are paid, the taxes are paid, the estimated things, and you can hold some money back in, and you can pay the beneficiaries, you can sell the house. So there's a lot of things you can do because you're not stuck in probate. You have a living trust, and you have somebody called a successor trustee is handling these things because you're no longer here, okay? And it's private. Nobody knows your business. I don't want anybody snooping around my stuff, knowing what's Michelle worth? Oh man, she's in a lot of debt. Wow, look at all the creditors after her. Okay, well, that's not the case, thank God, for me, but it's the case for a lot of people, and all they have is a house. And then that house has to go through probate. It's just not it's terrible, as you guys can tell. And another thing about a trust is what's so important: if you become incapacitated and you have your powers of attorney for finance and health, called a healthcare directive, there is no conservatorship issues that have to go on, okay? You have those documents in place. That person can step up on your behalf and talk to others on your behalf. You're still alive, but maybe you're in the nursing home, and they got to sell the house to pay for your care. If you did not have this power of attorney or your house in a trust, they would be stuck. They would not be able to handle your affairs and pay for your care and get to your money to pay for you. So you want to take care of this stuff before anything happens, and before somebody ends up in the hospital, and before somebody slips and falls. Don't wait till you're 80, 90 years old. Don't do it. Get on it now, and especially because we got, like I said, a lot of baby boomers are out there. They're retiring, or their parents are getting older and becoming, incapacitated, and they're stuck because they don't know what to do, how to handle their affairs, can't do anything. Let's talk about what an asset is. What is an asset that will go through probate? In California, and every state has their own rules, but every state's rules is usually property. Number one thing that will go through property. Minimum value on property is, I think the minimum value for everything that you have that is not, is over $184,000. So let's say you have bank accounts, you have motorhomes, you have savings accounts, and all that is valued over $184,000, and you pass away, and that's just in your name, that will be frozen and go through probate, a full-on probate, 2 years, 18 months to 2 years. Anything under that will go through a small estate situation where it's a simple probate, but that's still taking at least 6 months to get to those assets. If you've got insurance policies, I see this a lot. Now, insurance policies, 401ks, and IRAs, those do not get titled into your trust. Those stay in your name, okay? But a lot of people put their husbands on as the beneficiary, right? And then they don't have a backup. And then that person dies, and the husband passes away, and the husband who's entitled to that benefit never claims it, or he gets sick, whatever, and then there's no backup. That will go through probate. Insurance policies, IRAs, and 401ks are very, very susceptible to probate if beneficiary structure is not on there, and at least maybe having the trust as a backup is a good idea. A lot of people put their minor kids on these things. Don't do that, because minors cannot get money. And then you're going to have to hire an attorney to be a conservatorship over that minor's money. And then guess what? They probably get it all at 18. You really want your minor children to get a $500,000 life insurance policy at 18, because there's kind of no age limit. It's just a beneficiary. So just know when they're 18, they're adults. And if you put them on as beneficiaries, they'll get it at 18. I don't know anybody who wants their child to get anything at 18 years old. So a trust allows you to put an age in there. Have the successor trustee, you say, I want my kids to get maybe a third of everything when they're 25. That means they're through college and they've worked a little bit and they're a little more mature. Let's give them a little bit at 25. or give them all at 25. They're good. Or let's stair step it like 25, 30, 35. Great, but your estate plan will be personal to you, and we'll talk to you about that when you're ready to get started, if you want to. So with the AmeriEstate Trust, everything, our trusts include all of these things. Now, it comes in a really nice blue binder. I don't have a picture of it in front of me. I usually have it right beside me, but somehow it's not here. But it comes in a 3-ring binder. It says estate plan on the edge. You stick that in your bookshelf in your home office. You want people to know that you've done this, but you can still keep it private. You can put it in a safety deposit box. But once you set this book up, it's going to have all these things in it: your financial asset, power of attorney, your pour-over wills, your power of attorney for health care, which includes your advanced health care directive, putting your property into your trust, all the deed work that needs to happen to make your property go into your trust and protect it. Our notary is going to come out to see you and sign it and make sure everything's witnessed right. And also part of our living trust package is talking to the attorney on the phone. Everybody speaks to an attorney. I am not an attorney, but you will have a legal consultation, and then the attorney will direct us how he wants everything drafted. And then we're going to bring everything to you in your home, or you can come into our office. We're in Costa Mesa, but we work all over California, so it doesn't matter where you live. We can get it done for you. Our notaries are everywhere, and we work with you on the phone, by Zoom, but if you want to come in, come on in. And we also have, with every living trust, is our legal plan membership. We are called AmeriEstate Legal Plan, and that's how we are structured, because we were able to bring that cost down to you, and our attorneys have given us very favorable rates because we give them a lot of business. So you don't have to spend that $500 an hour. You're going to know exactly what the trust is going to cost out the door. Once we talk to you and see how many properties you have, is this for a husband or wife? Do you have a business? Just things like that we need to know. And then we're going to go ahead and pull your deed from our deed service. You don't even have to get in your files and shuffle around looking for everything. People put this off because they think they have to spend hours going through, here's my credit cards, here's my bank statements, here's my this and that. No, nothing like that at all. You don't need to do any of that. All we need to know is, who do you want to be your guardians of your children? Who's going to be your beneficiaries? Who's going to handle things for you if you can't? That means who's your successor trustee, who's your executor. Usually husbands and wives are the executors for each other first. They're first for their powers of attorney for health and finance, and then you'll think of a backup. Do you want to give anything to a church or a charity or a cash amount to somebody? Do you have a plan of how you want that money to go to your kids? So these are the types of things we're going to work with you up front before you talk to the attorney and get an intake form, so you can have a legal consultation, a meaningful legal consultation with the attorney, and we've collected all the busy work so he doesn't have to spend hours with you at $500 an hour. And that's why we are here as a legal plan. We can bring these services to you fixed, and you know exactly what you're getting. And then also the following year, we invite you to rejoin in the legal plan, which is an annual renewal, but it's not mandatory. And that helps maintain your trust, helps do amendments to your trust, gets you free attorney referrals. If you have an issue going on in your life, you need something else other than estate planning, it's like having an attorney in your back pocket. So just know there's some other great benefits to how we are structured. And an estate plan is, think of it this way. It's like you're setting up your own personal corporation that you own and control. Instead, it's your estate plan that you own or you've created and you control it. That means that once you set it up, you are the settlor or the owner, creator, and also the trustee or the manager, like in a business. You created the business and you manage the business. Now, what you're going to do is select a vice president of your business, your wife or whatever, co-owners, well, you together, and you're going to select kind of a succession if something happens to you. Who's that person going to be? Your successor trustee. It could be your kids, as long as they're 18 and mature, you think they can handle it. It could be a professional trustee service. They do this all the time. A lot of people don't know anybody, don't trust anybody. Their kids are too young. There's all kinds of things. So we can help you with that. We don't do that, but we can refer you. And then, and once you set it up, it's so easy to maintain. You just need to know the rules now. What are the rules once you set up an estate plan? The rules are, from here on out, once that thing is signed and notarized, we're going to prepare the deed transferring your home. Let's say you just have a house and you have it as Joe and Jane Smith, husband and wife as joint tenants. That's how everybody takes title, it seems. There's a better way to do it than joint tenant when you're married, but the best way to do it is having a living trust. And so we're going to transfer title from you as joint tenants. Transfers or quitclaims to you and Jane Smith, trustees of the Smith Family Trust, dated April 30th, 2005. That's it. That's the name of your trust with the date. And then from there, after you sign your document, you're going to contact financial partners and you're going to say, I got my trust done. Financial partners is trying to help you get this done and educate you because they want you to have a trust, because the problems that arise at their end, when something happens to you, you become incapacitated or you pass away, they get stuck and frustrated as well, because they're like, I'm sorry, but we can't help you because I don't have any documents to make anything happen. You need to go through probate. Uh-oh, what does that mean? So they are really trying to help educate their members by me talking to you. And then you can just, anytime you go into financial partners, just ask them, hey, can I get the number to AmeriEstate or the company that helps you guys with members, and they'll give you our number and you can call us direct. So just know that once you set it up, let's say 2 years later, you buy another house. Let's say you go open up a bank account somewhere else. Just remember, what's the rule? The rule is you have a trust. How am I going to title my new bank account? You're going to title it into Jim and Jane Smith, trustee of the Smith Family Trust, dated April 30th, 2025. Done. And the trust is just paperwork. You buy a house, you buy it in the name of that trust. Done. The house is protected. Great. That's it. Really, just remember the rules and you'll be fine. True or false? Does AmeriEstate cost 30 to 40% less than typical attorney fees? I'm going to answer that for you. Yes, absolutely. Like I said, attorneys have to charge a lot of money. They're kind of a one-man band and they spend a lot of time with you. They do, because they have to get to know you. They have to ask questions. They have to advise. They have to draft. You have to review. They need to call. It's a lot of time. So you figure $500 an hour, that's the going rate now. That's a lot of money. There are $3,000 to $5,000 estate plans or more. I see it all the time. With AmeriEstate, because we come to you in a team effort where we, non-attorneys, gather the initial fact-finding. Stuff that is not legal stuff. It's just, tell me what you want. How are your kids' names spelled? What are the addresses of your property? What's going on kind of in your situation? Do you have yours, mine, and ours? Or, all that stuff we're going to go through. We're going to take that time away from you. Once we get that together, that's going to go to the attorney. He's going to spend the time on the legal consult. We're going to do all the drafting of the documents on his, with his instructions. He's going to see a copy. He's going to approve it. And then he's going to say, this one's good to get delivered. And we're going to go from there and get it all delivered. It's about, I would say, at least $300 to $400 in notary work that any notary would charge you, because there's a lot of signatures to be done. So it's all included in the price. So let me tell you what that is, because I'm sure you're all waiting to hear. So for a single trust is $18.95. trust is $19.95. Everything included. On top, that's for the trust. Now, what's not included and we add on is properties. If you have one property, it's an extra $250 because we got to prepare the quitclaim deed, do all the extra forms that go to the county, and then there's a $60 recording fee. But that's it. Everything's included. That would be it. So just know that's about the pricing, and we'll talk to you about what else do you have. Do you have a business? Do you have separate property you want to keep separate? We can do that. We can keep separate property in a married trust. So many things we can do. So just know that that's kind of the basic pricing, and it really doesn't go up much from there. It's just based on, okay, how many properties do you have? Do you have a business? That would be like an extra $250. So here's, like I said, I've already talked about this, but if you hire a traditional attorney, you will pay about this much. I know for sure, because when our marketing director came to work for us, Caroline, who puts all this together for me, she got her trust done. She was referred to an attorney from her tax advisor, a financial planner, I don't know. And she paid $6,500. And I was like, oh man, you know. She goes, I know. She goes, but they gave me a really nice box of chocolates for Christmas. I hope it was good. So it's true. That's how much they charge. Now, let me tell you a little something about, you might see some cheaper trusts. There's some companies out there are just really advertising a lot for these $6.99 trusts. You guys might have gotten some yellow flyers in the mail or whatever's going on. There's a reason for the cheap price. I know this because I've been doing this for 27 years. Really what these people are interested in is selling you other products. They're getting their foot in the door to get your trust done. They can come back around after and talk to you about other things. So I know this for a fact. We don't have anything to do with that. We want you to have your estate plan, and so does financial partners. You're already with financial partners. They're going to make sure that they help you fund those assets that you have with them into the trust, so we can work with them as a team. So just know that, just be really wary if you see really low prices like that. I'm telling you, it's a trap, okay? So again, here is the pricing, and we do have financing and payment options for you, meaning that if you want to do, we have like PayPal, and we also have Zelle. You could do it as Zelle, and oftentimes you can pay half up front and half later, but we don't have, like, we can't do anything where you pay $100 a month, kind of like getting on a dental plan. We don't have that. We just don't have the capacity to do that kind of billing. So it's either half or full up front, and everything's going to be done within 6 to 7 weeks, okay, in your hands and done. So just a little bit more about other things we do. If you have family and friends, or maybe you or a family member has passed away and you need help settling that person's estate, we can help guide you. So we do trust administration. Just give us a call and we'll coach you and kind of talk to you about it. And then we'll just tell you how much we charge per document we're doing. Sometimes it's not much. Sometimes it's a little bit more based on how many beneficiaries we have to send letters to. And we can do the deed work, transferring houses into whoever's going to take on that property. We also do business formations if you want. If you have a business that's in sole proprietorship, or you're going to form something and you need an LLC or an S Corp or C Corp, let us know. If you have rental property you want to protect from asset litigation, asset protection, let us know if you want to do an LLC to put a bubble around that, because anything that's in your personal estate, so you kind of want to transfer those things outside. So whoever's coming after you isn't going to go to the whole bucket, right? So we can talk to you about those things. And anybody who you think might be incapacitated, as long as they have a power of attorney in place for financial affairs and a healthcare directive, we can help do some incapacity planning, get the documents so you can go to the bank to handle things at the bank. I wanted to talk to you about, let me go back. I just got my hip done 2 weeks ago. I have a new titanium hip. When I was getting all prepped and ready and all this, they said, do you have a healthcare directive? I'm like, yes, I do, right? So I've uploaded that to my portal in my Memorial Care portal, but they lost it. They don't have it. So I'm glad. I mean, anytime you go in for surgery, they want your healthcare directive, right? But wouldn't it be great to say, I got that? So just know that's going to be the thing they're going to ask you the day before you go in, and you'll be scrambling like, no, I don't. Oh, my God. So just get those things done so you have them. So when that surgery comes up or whatever goes on, you got it. And that has HIPAA in it. The right to die decisions, meaning if you're on life support, do you want to stay on it? A lot of people have nothing in place, so they're just living like a vegetable, and they probably on a life support machine, and nobody can take them off. So just know that those things happen. So if anybody here who's interested in getting started on their estate plan or wants a little more info, or we can give you a quote on the phone based on what you have, get to know us, feel free to use this QR code here, or call this number, 866-671-4529. And our inside team will answer that call and just let them know you saw the Financial Partners Estate Planning 101. And they're going to put you in touch with Cassandra or Florence to help you understand a little bit more about your situation and ask you the questions. What I'm doing today is I'm not trying to sell you a trust. Obviously, we want you to get one. And it would be great if you give us a call or call Mario and his team. They'll put you in touch with us. But at least start thinking about it, because if you're anywhere close to getting retired or your parents are getting older, it's the baby boomers are booming right now. And this is the time to take care of business if you haven't already done it. If you have an existing trust, be aware that could be kind of old and not what you need or what you want anymore. You might not have proper language in there to handle things if one of you passes first. So it's really important that you send us a copy. If you want us to look it over, we will do that for free. And we will tell you what it's missing. And you can decide what you want to do. Okay, so just know that that's available to you. And you're welcome to call us or reach out to Mario or anybody on Mario's team about that. I think I'm done here.